Quickie fold. The case of Blackledge v. Perry established that prosecutors cannot add new charges just because the defendant exercised a constitutional right. A prison inmate in North Carolina got into a fight with another prisoner and was charged with misdemeanor assault with a deadly weapon. He was convicted in district court. In North Carolina, district courts are inferior courts, generally with hearings in front of a magistrate. But since you have a right to trial by jury, you can always appeal to superior court, which is where jury trials in larger cases are heard. And because of that right, you also have the right for that appeal to be de novo. So, Perry appealed, but the prosecutor used that as an opportunity to obtain a felony indictment for the same conduct. In other words, in retaliation for exercising his right to appeal, the prosecutor punished him with a bigger charge, and he used that to strong-arm Perry into a guilty plea. That absolutely contravenes the Due Process Clause of the 14th Amendment. Potter Stewart, writing the opinion of the court, cited North Carolina v. Pierce, which said, "Imposition of a penalty upon the defendant for having successfully pursued a statutory right of appeal or collateral remedy would be a violation of due process of law. Vindictiveness against the defendant for having successfully attacked his first conviction must play no part." The Pierce court also mentioned the chilling effect that might have on defendants wanting to exercise their right of appeal or otherwise insist on their constitutional rights. Stewart wrote, "A prosecutor clearly has a considerable stake in discouraging convicted misdemeanants from appealing. If the prosecutor has the means readily at hand to discourage such appeals by upping the ante, the state can ensure that only the most hardy defendants will brave the hazards of a de novo trial. A person convicted of an offense is entitled to pursue his statutory right to a trial de novo without apprehension that the state will retaliate by substituting a more serious charge for the original one, thus subjecting him to a significantly increased potential period of incarceration." And remember in the Berger decision that it is not the goal of the prosecutor to get convictions or long sentences, but that justice shall be done. If the prosecutor had thought that Perry's offense constituted a felony, he could have just gone ahead and prosecuted it in superior court. This decision doesn't bar prosecutors from bringing charges they think are just. It just prevents them from upping the ante if the defendant does something to insist on his rights. Prosecutors have way too much power in this country. It's good that the Supreme Court has been chipping away at it, but it's been way too slow.